Chief among these checks would be appointment. As a general rule, whoever you appoint on the court would typically be reflective of your political and ideological beliefs. It would be expected that a president who would be conservative would appoint conservative members of the court. A president that is liberal would be expected to appoint liberals to the court. So this appointment power can be used to try to steer the ideological direction of the court. Statutory amendment. It should be noted that much of the Supreme Court's work does not necessarily concern the interpretation of the U.S. Constitution, but rather concerns what do individual federal laws mean. If the Supreme Court, or for that matter any other court, interprets a law in a manner that Congress doesn't like, Congress could in fact amend the law. Again, there's no constitutional consideration. All the court is doing is saying this is what the law passed by Congress means. So, if Congress disagrees with that or wishes to change its mind, Congress could pass a new statute or amend the previous statute, and that would have the effect of overturning the precedent that was created in that case. Constitutional amendment. If the court were to interpret the U.S. Constitution in a manner that was not agreeable to Congress, Congress could propose a constitutional amendment and submit it to the states by 3/4 vote, and the states could ratify the constitutional amendment submitted to the states by 2/3 vote, and the states then could ratify it by a 3/4 vote. Impeachment. This would be the process of removing a justice from the court. If the Congress was dissatisfied with the decision making on the court, or as a check against corruption, individuals on the court could be removed through the process of impeachment. The House, by majority vote, can vote to impeach, where then the Senate would conduct a trial, and if found guilty by 2/3 of the senators, then the individual concerned would be removed from his or her position. Restrict jurisdiction. The U.S. Congress, under language found in the U.S. Constitution, can and has restricted the appellate jurisdiction of the U.S. Supreme Court. The original jurisdiction of the Supreme Court, the Congress cannot expand or contract. However, the appellate jurisdiction of the U.S. Supreme Court can be restricted by Congress. Congress could say, pass a statute, and then in that statute also remove the ability of the Supreme Court to consider whether that statute was constitutional or not. The degree to which the Congress can jurisdiction strip, as the term is known, really is subject of some constitutional debate. Could Congress flat out deny the judiciary the ability to review its actions, or could it say that this court can't hear this type of case, but another court could? So legal scholars are still debating that one, but the fact that the Congress can restrict the jurisdiction of the court is without question. Absence of compliance. This is where people simply ignore the court. The quintessential example of this would be Andrew Jackson ignoring the decision of the court concerning the Cherokee Indians, and not only did he ignore it, he flat out violated it and ordered the Cherokee Indians at the end of guns by the U.S. military to be removed from their territory in Georgia and sent to the state of what would become the state of Oklahoma. A more contemporary example would be pockets of instances where you have absence of compliance. The U.S. Supreme Court has ruled through a number of court cases that you cannot have school-sponsored organized prayer before high school athletic events such as football games. But I can assure you that this coming fall that there will be, in small towns all throughout the United States, prayer led perhaps by the local pastor before a high school football game. It'll be conducted on the loudspeaker, and perhaps most of the people in the stands will join in, and there will be nothing that the elected school board would do about it. There's going to be nothing that the elected city council will do about it. There's going to be nothing that the elected sheriff will do about it. Now, obviously, if someone complains, that may be different, but there's nothing the court can do about the absence of compliance on these at this individual level. Closely related to this would be foot dragging or lackluster enforcement. This isn't bold-faced defiance of a court decision. This is whenever you engage in delaying tactics concerning the implementation of a court decision. So the term is used, foot dragging. This is whenever you take you're obstructionist and simply delay as long as you can the actual implementation of a judicial decision. So now we're tasked with the job of trying to figure out which one of these checks actually work, if any. The first one, appointment. Is appointment an effective check on the court? Again, we're going to look at, we have the list of checks on the court, but now we're concerned with, do they actually work? Does appointment actually act as a check on the court? Well, to a certain extent it does. Past behavior is the best indication of future behavior, but it's not 100% effective. Just because someone was conservative in the past doesn't mean that they'll be conservative in the future, but they are more likely to be so than someone else. So appointment is somewhat effective, but not totally effective. Statutory amendment is probably somewhat effective. It's not totally effective because passing another law is very difficult. So while Congress, or many in Congress, may wish to overturn a Supreme Court's decision as to how they've interpreted a particular statute, doing so can only be done with great difficulty. So statutory amendment would only be somewhat effective. Constitutional amendment. If the U.S. Constitution is amended in a manner that Congress finds objectionable, so the theory goes, they can amend the Constitution or propose an amendment, that is to say, and submit it to the states. Constitutional amendment is wholly ineffective as a check on the Supreme Court. The Supreme Court has issued hundreds of rulings that have been controversial and not necessarily well received, although there's only three decisions that have been, three amendments that have been directly aimed at overturning a Supreme Court decision. So it's, I would say, wholly ineffective at overturning or acting as a check on the court. Impeachment. Obviously, if you take someone off of the court, then that could affect the judicial decision making. This is ineffective. 200 years ago, whenever the Federalists took over, whenever the Jeffersonians took over after the Federalists lost the election, and the Federalists had stuffed the bench with their cronies, the Jeffersonians wanted to get rid of as many Federalist judges as they could. And one of the ways that they were going to do this was with impeachment. However, cooler heads prevailed, and it was realized that if you go and begin to impeach justices and judges based upon their political or ideological beliefs, then we're going to go through this process every 4 to 8 years. So as a tradition, we do not impeach or remove justices or judges based on their political beliefs. Absence of compliance would be somewhat effective, but eventually you're going to have to come into compliance. So at best, it's somewhat effective, but over the course of time, it becomes non-effective. So of the different institutions under the Constitution, I would say that the court is perhaps the most independent of the constitutional three: Congress, executive branch, judiciary. The court is the most independent of public will, but not totally removed from it. There are some of the executive branch officials that do interact with the judiciary. So while these officials are in the executive branch, they aren't judges, they're not members of the court system, they do interact with the court system and help in the creation of public policy. First among them would be the Attorney General, and not really. The U.S. Attorney General does have the authority to represent the United States in the Supreme Court, although it is incredibly rare. The U.S. Attorney General is primarily concerned with running the Justice Department, which for the most part is a law enforcement agency. Don't be confused by the fact that most states' attorneys general do in fact represent their states in the judiciary. That is not the primary job of the U.S. Attorney General. Representing the United States at the Supreme Court level is a position called the Solicitor General. It is the job of the Solicitor General to represent the United States when the United States is a party to a case, which is not always. Sometimes it might be person versus person or person versus state. In that instance, the Solicitor General would not have a direct role to play. But if the United States is a party to a case, it is the job of the Solicitor General to represent the interests of the United States. As previously mentioned, the Solicitor General will on occasion file amicus briefs that give the position of the United States if the United States is not a party to a case, and those amicus briefs are usually reviewed by the justices, although not every justice obviously will agree. Lastly would be U.S. attorneys. United States attorneys represent the United States in federal district court. They are executives. They are concerned with ensuring that individuals follow federal law, and when they do not, they are prosecuted by them. So at the trial court level, the district court level, the U.S. attorney will act as a prosecutor, prosecuting those individuals that they believe have violated federal law. Lastly, we have judicial review. This was covered in the chapter dealing with the U.S. Constitution, but let's talk a little bit more about it. Judicial review is defined as the ability of the federal judiciary, not just the Supreme Court, to review actions of the other two constitutional branches, not just the Congress. So, could a district court invalidate an action of the President of the United States, such as an executive order? And the answer is obviously yes. So, judicial review, again, is the ability of the federal judiciary to review actions of the other two constitutional branches, Congress and then the executive branch, including the President and the bureaucracy. Judicial review is nowhere specified in the U.S. Constitution, but rather it flows logically from it, and it was first established in the case of Marbury versus Madison. Again, judicial review is not explicitly stated in the Constitution, but does flow logically from it and was alluded to in the Federalist Papers. How often does the federal judiciary overturn acts of Congress? It is very rare. In fact, the court will go out of its way not to, very often misinterpreting a statute in an effort not to overturn it. So the court does have a great deal of deference for actions of the Congress. However, they don't have nearly as much deference for acts of state legislatures. So it is far more common for a state law, if it is challenged on its constitutionality, to be overturned than it is for an act of Congress to be overturned.